Okay, kom ons was so bietjie. Dat is net 'n bietjie kommentaar kry. We gaan poppelen. Goeienaand ouens. Dis later as wat ons gewoonlik die dinge sal doen. Ons het maar net 'n redelike bedrywige dag gehad. Klomp goedjies wat afgehandel moes word. Maar ja, ons is hier. Leonie, hoe gaan dit, my skat?
Dit gaan baie goed. baie goed. So wat ek het om te sê, dit gaan goed.
Ja, let's not say too much.
Ja.
Maar in elk geval, daar sy. Och, dit is vir my pragtig as dit so vinnig oplaai. Goed, ouens, ons gaan vanaand sommer net 'n klomp onderwerpe cover. Going to cover a lot of subjects for the very simple reason we've been going through our older videos and seeing and looking at what's troubling people. So it's going to be a mixed bag. Hopefully not too long. Let's keep it as short as possible. So yeah, Leonie.
Okay, the first one is universities.
Yeah, lots of questions about universities. From day one, my advice always was the following. Remember, there's not a Labour Relations Act to provide coverage or protection for students. There's not all the legal framework that we have in workplaces. Therefore, students, your situation is more precarious. We've seen a lot of the universities adopt very strict vaccination policies. Now, how do you counter that? Very simple. There's basically only two ways of countering this. Three ways. Let's call it three ways. The first being if you have the funding and you have the resources and you have the time to go to High Court, it's going to have to be a High Court order and simply interdict. Fight in court, but interdict the university from doing this. However, as I say, we're looking at quite an amount of money that will have to be utilized for that, and maybe the possibility of a lot of time. That's the first option. The second option, which is the simple one, the easy one, the cost-effective one, is always going to be South African Human Rights Commission, but there we need masses of students referring cases simultaneously to the South African Human Rights Commission as a violation of their constitutional rights. The objective of this is simply to flood the administration, the legal department of universities, to make it basically impossible for them to go and fight all the cases. Imagine yourself what will happen if in a given situation 1,000 or 2,000 students refer cases simultaneously. It's going to cause such administrative havoc in that university that they will have very little choice but to simply budge on the issue. So that's the second option. Third option, I see some of the student representative councils now started to listen to their members. I'm very glad to see that. And there's also a student union. I can't specifically now recall the name of the student union to which certain of the students belong. So if you can fight collectively, also do that. You will maybe in future start thinking about a civil protest. But please keep it peaceful. Don't burn down stuff. Don't destroy the university that you intend to study at. Please don't go to those extents. There's various ways of civil disobedience that's totally peaceful. Please go and explore that. Students, you can do this. You can stop the vaccinations on campus. Parents of those students, it's also within your reach to do that. So I'm not going to get involved in the whole issue of universities. I simply do not have the time to do that. It's impossible. We're speaking of huge chunks of work per university. I simply do not have the resources or time to do that. But please follow my advice and start referring cases en masse to South African Human Rights Commission.
All right, Scott, the next one is roadblocks.
For which I was even in rapport. Thank you. Shout out, Jana. But unfortunately, the ombudsman is still on the cards. Yes, roadblocks. I think we stopped the whole thing in its 4 tracks. I think the message came across very strongly that we will not allow people to be forcefully vaccinated at roadblocks. As far as I'm aware, over the holiday season, there was not one incident. Nothing was reported to me in any event. So not one single incident. I think we pretty much passed the threat of roadblocks. I don't think we're going to see that ever again in South Africa. Once again, thank you, Rapport. I think you managed to give me a platform that otherwise I would not have had. So that's the positive. Unfortunately, you really made a hash up of the whole presentation of the story, for which there will be action taken. But yes, roadblocks, it's I don't think we need to see it as a threat anymore.
Okay, the next question. Someone asked, how do you prove to your employer that the vaccination that you got made you sick?
Okay, that goes to the broader issue of how do you prove vax injuries, or injuries for that matter, any adverse effects. That can only be proven through medical expert testimony or evidence in front of a court, or then if your employer is willing to accept that per se or de facto, that's also fine. But how do you prove any medical case? And that is what make these cases so extremely difficult and costly, is that you need expert evidence. The court itself is deemed to be the expert of law, but it's not deemed to be an expert of any other field of expertise, i.e. medicine, i.e. Injuries, adverse effects, and so forth. So for that, you're going to need an expert, a proper expert witness or witnesses to establish what is called chain evidence as from, where you receive the vax all the way until where the vax injury was noticed the first time, experienced the first time. And that is why you will remember in earlier videos I said, please, if you go for the vax, please go to the doctor before you go there, so that you have a clean bill of health, or at least you know what illnesses and underlying illnesses you may have, and then only go for the vax, because then we have a set point to start off. If there is any adverse effects, it becomes so much easier for us to go and trace it back to a certain finite point and say it was because of this vax on this day that the following then occurred, because there was no medical history prior to that. But it's going to be done through expert testimony by a proper medical expert, i.e. this is usually specialist doctors, not only your usual doctor, your GP. It's usually a highly trained, highly skilled doctor that's also skilled in the law of evidence, so that he can present properly in a court of law.
Okay, and the next one, someone said something about pharmacies who don't want to help people with chronic medication when they're not vaxxed. So the one person, they just said they took their prescription to another pharmacy. So that's one option. But then someone else asked, they want to know about their medical rights for people on chronic medication.
Yeah, look guys, you have the discounts of the world. That's business stupid to go and also try and enforce these things against their clientele. Now, I call it business stupid. If you're a business person, you do everything to your possibility and your availability and ability to gain more customers, not to lose customers. Now, if you want to adopt a policy where your core clientele is then not being serviced, and in South Africa 7 out of 10 people approximately is not vaxxed. The vast majority of South Africans have not received vaccinations and are clearly not interested in receiving it. That is simple business stupidity. My advice is simple. Don't even go and fight that pharmacy. Just simply take your business to another place, to another pharmacy. Okay. What do we do with small towns? Maybe there's only one pharmacy, or one pharmacy very in close proximity to yourself. It's difficult for you to travel to the next one. Then it becomes more difficult, but then it becomes theoretical once again, where you have to enforce your rights through a court order or through the professional body to which pharmacies belong. But that's going to take time once again, and maybe resources and money. Medical rights, of course you have a medical right to medicine if you can afford it and it's been prescribed or it's been sponsored by state or medical funding or whatever. You have rights, not privileges, rights. People must make that huge distinction. I'm not criticizing non-vax, co-vax the tennis player, but I'm very disappointed in some of his rhetoric, speaking of the freedoms of people and the privileges of people. These are not freedoms and privileges. These are your rights. It's a very strong, much stronger concept than only a freedom. A freedom is something that can be taken away. A right is something that cannot be taken away unless it's being taken away through a court of law.
Okay. Then there was someone who says they're working for a hospital, and the hospital told them that the Health and Safety Act said the mandatory vax was validated because they have to protect their patients and their staff.
Look, we're not there yet, and I don't think we will necessarily get there. But frontline workers and hospital workers, healthcare workers, I can understand if we were dealing with a real pandemic. We were dealing with people really dying in their thousands upon thousands. You would see people dropping on the streets. Then I would imagine it would make sense for those institutions and those employers to have vaccination, so-called mandates, procedures, policies, whatever you call it. But at this point in time, there is no legislation per se. There's the nose wiggle, the famous called nose wiggle. But anyways, and there's that word also. No, I'm joking a little bit. We just had a very fun day. But yeah, that's the problem with this whole thing. And I don't have quite a short answer for it.
Okay.
Yes.
Sorry, the next one. The court case that said the lockdown is illegal.
Okay. We're dealing with
for the extensions.
Yeah, we're dealing with the beer case, the beer versus COCTA. COCTA being the Department of Cooperative Government and Traditional Affairs, the famous Zuma Koptuk. We're dealing with that case. That case dates from last year. Now, what happened in that case, and please don't take this as criticism, me criticizing anybody, especially not me criticizing Reino de Beer, who drove that case. I have tremendous respect for the guy, so don't see it as criticism. But what happened in that case is that he was successful with the case in the court of first instance, and that being the Pretoria High Court. He won that case. And in that case, it was decided without any doubts by the High Court in Pretoria. And Pretoria High Court is known for its more conservative views on certain issues. But it was found by that court that the lockdown is indeed illegal, and a lot of the lockdown procedures and policies are indeed illegal and unconstitutional. It was then taken on appeal. Now, if you're dealing with a constitutional issue, and you can go and read the Constitution itself, you can go and read the law surrounding that, that does not mean that in an ordinary appeals case, I hope that the rain is not filtering me out. It's raining cats and dogs now in Pretoria. But in a usual, in an ordinary appeals case, you will have a suspension of the original court order whilst the appeal is pending. In a constitutional issue, however, there's a distinction to that, in that the original court order is not suspended pending the outcome of the appeal. But what happened here is that it was deemed. I think that the lawyers just simply screwed the whole thing up. With the greatest respect, guys, once again, the media certainly screwed it up, and they reported it incorrectly. And eventually that case was indeed overturned. In other words, then Reino lost at the appeals court, and the court order was overturned at the appeals court. So that court order does not stand anymore. Now it becomes interesting, because did it set a precedent, the appeals court judgment? Did it create a precedent? In other words, we can't go and test it again, or another court can't make a different decision? Frankly, I do not think so, because in the meantime, new legislation and new regulations were indeed published and promulgated by government. So I think if there's somebody brave enough out there and with deep enough pockets out there, we can certainly once again take this whole issue of lockdown to court again, and I think we will definitely win again, especially in Pretoria High Court, and I wink now on that one. But yes, it can be done. But at this point in time, unfortunately, that court case, it was a tremendous victory. That court case, unfortunately, the judgment in the original court of first instance is not applicable any longer. I wish it was, but it is not. So unfortunately, that's the situation.
All right. The next one, is there any law against wearing masks? Because it's actually making us sick.
Yeah, I have a big problem with the whole issue of wearing masks. To me, it's a control measure. It's nothing to do with medicine. If you believe that a cloth mask can stop the distribution or the spread of a microscopic virus, we're speaking an organism. I don't even know. I'm not a scientist. I don't even know if it's deemed an organism. But if you're speaking of something so microscopically small as a virus, I mean, you can't stop it with a mask. I can understand the whole issue of when you sneeze maybe or speak, whatever, it causes saliva and the outflow of a certain amount of moisture out of your nose and your mouth. I can understand that. But then the problem is still, if you go and look at the actual reduction, we're speaking of maybe 10%, 20% in the reduction of the possibility of the spreading of a virus. To me, a mask is a control measure. Here's the bad news. They are contemplating, and I have this on very good authority, they are contemplating definitely to enforce masks for a very long time to come. There will be actual legislation dealing specifically with that issue.
So I'm going to be chased out of buildings quite a few times.
You're definitely going to be chased out of buildings.
Yes.
Guys, I just want to have an indication from you. It's raining heavily.
Yeah.
Is it affecting sound in any way or measure?
Otherwise, I have to close the windows.
Okay, let's proceed. Please,
Okay,
if you can't hear us, just indicate.
Yeah, just let us know.
Okay. There's thumbs up and thumbs up, so I think we're fine. Let's just run with the thing.
Okay. What if your employer doesn't want to accept your medical certificate or your reason for not wanting the jab?
With the greatest respect to employers, and sometimes they become very narcissistic. They become very a god unto themselves, a law unto themselves. If a medical expert, i.e. a doctor, says that the person cannot receive a certain medication, whether that's COVID related, whether that's anything else, the medical expert said it's so. The only way, Mr. Employee, you can stop that or you can change that is to send that person on your cost for a second opinion. But it's not for you to dispute that. If a doctor says a person cannot receive a vaccine, that's the final word on it until such time as either a court of law or a second opinion or maybe a third opinion differ from that. And then maybe you will have a foot to stand on. But no, it's not for you to decide that.
And then also, last time we saw someone said the Tongaat Hewlett workers want to contact us.
Yeah.
So please feel free. We haven't heard anything from you yet, so we're waiting for you.
Yeah. People, I will make a video again for you of how the inboxes in Station van der Merwe looks like. I'm not speaking of, at this point in time, dozens. I'm speaking of hundreds, if not thousands, of messages in all our inboxes, whether that be email, WhatsApp, SMS, even Facebook Messenger. It's very difficult to handle that flow, and that is why we started asking for assistance from volunteers. And volunteers, thumbs up. I've started receiving resumes and CVs, so I'll be working through those, and I hope within a week we will have a running team with this issue. But at this time, if your call is not answered immediately, we will get to you eventually. But please now, we have a multitude of the same questions and the same issues being repeated. So you will find 100 cases or 100 inquiries about the same issue over and over and over and over and over again. It becomes a senseless exercise to go and answer all those things with exactly the same advice. And that is why I do the videos. That is exactly why we have videos that's easy to listen to. I don't use high terms, Latin terms, legal terms, making it difficult for people to understand. And usually I quote directly from law, or I tell you exactly where in law you will find a certain thing. So rather go and listen to what is there out already. There's multitudes of videos basically covering everything related to COVID, mandatory vaccination, dismissal, suspension, everything is already there on video. So before you send that message, make sure you can't just simply go and listen to a video. Because unfortunately we're now bottlenecking, we're blocking people that need real help. We have the dismissal of employees on a daily basis now, that we need to help now. Otherwise, those people are really going to have a struggle in future. If you run past your 30 days at CCMA for referral of the case, you have to do an additional condonation application, which is not difficult and usually successful, but it's a rework. It's unnecessary to have a second tier, a second loop to jump through. So yeah, please go and rather watch the videos before you do that. Tongaat employees, please come into contact with me. I know there was a shout out at one stage. I cannot remember specifically that you came to me. If you did, I apologize. But I can't specifically remember it. But please go ahead with that.
All right, and then people are having problems with the employers paying their bonuses and their money. Yeah.
Okay, let's speak about bonuses. Bonuses, always contentious. In fact, my employer parties are usually advised do not have bonuses as far as possible. For the very simple reason, bonuses usually causes disputes. It makes people very happy or very unhappy, depending on whether you receive or don't receive your bonus. Now, if a bonus, so-called bonus, is part of your conditions of employment, typically what is called a 13th check or 14th check, sometimes you even have that, or it's part of your bonus structure. It's usually production bonuses, quantity bonuses, whatever. If that is part of your conditions of employment, there's somewhere that you signed an actual agreement or contract relating to that, then you can enforce it as a payment. If the employer then does not give you your bonus, you can go to the Department of Labour. Yes, I know it's a slip, but that's the easiest and the most cost-effective way. Or you can go to an attorney, but usually then the employers run into the hills and they start using their own legal teams. But if it is a part of your conditions of employment, you can enforce it as a non-payment of monies, of salary or as income. But if it's simply a bonus, it's simply something given in addition to bona, and the employer is within the discretion to withhold it or give it or don't give it or whatever the case may be, then you don't really have a foot to stand on. Where it can become applicable is where you're unfairly being discriminated against because, for instance, you didn't take the vaccine, now your bonus is withheld, but anybody else that did receive it, they now up for their bonuses. Then you can definitely make out the case once again South African Human Rights Commission as unfair discrimination against you based on your constitutional rights. But yeah, the employer, if it's a simple discretionary bonus, there's no obligation on the employer to pay it to you.
Okay, and then people are asking again about hospitals that refuses entrance and treatments if you're not vaccinated.
Yeah, doctors, hospitals, nurses, any medical staff, they are bound by law, by their profession and by their ethical code to assist you as a patient. So no, they cannot refuse you. They simply cannot refuse you. If a doctor does that, a nurse does that, a sister at the hospital does that, or the clinic does it, whoever, a medically trained person, then you're definitely within your rights to lay a formal complaint against that person with the applicable professional body to which those people register. So please do that. If a doctor is being difficult, please do that. During a live Zoom meeting a couple of weeks ago, I spoke to about 500 to 1,000 people, I can't remember, somewhere down in the Cape. The question came up that in their little town, it's there somewhere up in the West Coast, both the doctors, they have two doctors in town, both of them are extremely pro-vax. And therefore they are now forcing people to either vax or they simply say, no, we're not going to treat you. That's absolute nonsense. That's absolute nonsense. Go to the medical council and go lay complaints against those people. If there's an injury or an adverse effect, or they cause you further damage or further harm or further illness or whatever, then of course there's a civil case, a civil claim against them. But once again, it's difficult. You have to go the route of expert testimony, etc. But yes, it's absolute nonsense if a doctor or any other medically trained person refuses you treatment because of your vaccination status.
All right, and then tell us a little bit more about exemptions and condonnations.
Okay, condonnations are less well known, or the term for that. In accordance with the CNN mantra of mandate, now the employer must have a so-called exemption to the mandate. This is not law, it's nowhere in the law, it's simple policy, it's at most policy. We will get back to the issue of mandate versus law, because that's become a hot topic too. But the long and the short is that in many workplaces they will have to apply for so-called exemption. I usually give the advice to go the route. Don't kick against it for the very simple reason I have people now being charged before disciplinary inquiry saying that they did not want to comply, and they put their fellow workers in harm's way. There's maybe a case to be made out by a person in a disciplinary hearing about that. So go for the exemptions. Exemptions are usually given then on so-called medical grounds. It's given on religious grounds, and then constitutional issues. It's usually those three things. But you will find often that the so-called exemption boards, who are these people? It's usually the employer themselves. It makes a mockery of the whole system. They usually don't grant those exemptions. Be very careful about the medical one. The medical one can cause you a lot of trouble down the road. If you have some underlying medical condition that can cause you to become incapacitated in future, or they can make out a case to say that you're not really in a healthy or healthy enough to work in a certain workplace, it can cause you problems down the line. So be very careful of the so-called medical exemptions. I assist people with medical exemptions. I've done, I don't know how many hundreds of exemptions for people. But unfortunately, a certain percentage, I would say 1 out of 3, is usually not effective. It's better to simply hammer them with law. If the whole issue of exemption comes up, and I have a thing tomorrow, so-called Zoom investigation tomorrow, where we kept on fighting, and we actually saved quite a few employees at that specific workplace, to the extent they are also now called in an advocate. I ruffled his feathers a little bit today, and then we understood one another much better after that. But the employer has gone to those extremes now, and I think they're just simply going to drop the whole thing after this meeting tomorrow. But that's just one example. Rather hit them with law. I don't believe in these things of exemptions, but once again, don't kick against it and cause them to find a reason to take disciplinary action against you.
Okay, then someone asked, what happens after CCMA when you're dismissed for unfairly dismissed? Do you get a job back, or do you get compensated?
Okay. In dismissal cases, the primary remedy, in other words, the first remedy that must be considered by a commissioner is reinstatement. Reinstatement means that you're sent back to your work under the same terms and conditions as previously, and the time that you've been out of work is then paid out, not as compensation per se. You reinstated into the position as previously, as if you were never dismissed. So that is the primary. The second option, the second remedy, after that is re-employment, where the CCMA will put you back into a position in the workplace that was similar or is similar to your old position, but you're not paid for that time that you were sitting at home. And the third option, of course, is compensation. And compensation is sometimes the most practical thing. I was a commissioner at CCMA and the Bargaining Council for many years, and many times you will have disputes in front of you where the the relationship between employee and employer is being damaged to such an extent that nobody trusts one another anymore. It's like a marriage. If the trust is broken and the relationship becomes sour, it's very difficult, if not impossible, and sometimes very impractical to simply place the worker back into the workplace. They will find some reason to kick him out and then fire him again in future. So then the CCMA will usually look at compensation. Most cases settled at CCMA is for compensation. You will very rarely get an employer to come to CCMA and say, hey, I made such a big mistake, I will take this worker back. It's very, very rare. I would assume one or two cases out of thousands. Usually the employer will come and they will offer a certain amount of money, and that money is usually about 3/4 the amount that they calculated they will lose if they go on arbitration and they indeed lose the case. Sometimes, especially highly paid employees, they will offer less. Less paid employees, they sometimes offer a little bit more. And then, of course, there's a very practical legal thing also. And that comes down to review of cases. Now, what happens is that you go and sit with your employer, if you're the consultant representing him, or the employer or organization representing him, and you say to him, if we lose this case and we take it on review to Labour Court, which we can do, it's going to cost you about 70 or 80,000 rand. If you lose the case, it maybe can cost you 120,000 rand. So let's rather then settle the matter for a lower amount than we possibly will face, but not that low, so that the people are tempted to take the case on review should the arbitration go ahead. So it also becomes a cost factor for employers to rather settle the case than face going to what do you call it, a Labour Court or Labour Appeals Court with that case. Here's the footnote. I saw people becoming totally deurmekaar and confused as to what is a finalised case at CCMA. A finalised case is a settled case. If a case is not settled in full and final, it still is open for review at the Labour Court. So if I speak about a case finalised, it's not a case won through award at CCMA. It's a case settled full and final between the parties. A case won at CCMA has the inherent capability or the inherent possibility of being taken on review to Labour Court at huge expense sometimes and set aside there. So it's not a finalised case. So even if you win a case, and you will find sometimes employers, especially going after workers to Labour Court, going and reviewing for the most silly reasons, fully knowing it's impossible for the employee to go to the cost of fighting the case at Labour Court. Labour Court, by the way, it's a high court, so we're speaking of tens or thousands of rands of legal costs if you go there. You can go and fight yourself, but it's very technical, it's high court litigation. So sometimes the better option is just simply to settle the matter, especially if the amount of compensation is to your suitability, and just simply move on with your life and go and find another job.
Yeah, wow. The thunder.
Thor is hitting the hammer.
Okay, also someone asked about an incapacity inquiry.
Incapacity? Yes. It seems to me that 2 out of 3 cases now that goes to the point of dismissing employees not vaccinated boils down to so-called incapacity. We've covered this aspect in full in a previous video, but let's recap. Incapacity means that your work is affected. Your work standard or quality or production or quantity is affected. Then the employer by law can do an investigation. He must gauge and see why you are not performing up to standard, and then gives you a certain time and certain remedial action to assist you to get to the standard. And then if you do not perform, then he may dismiss you within the bounds of law.
But not because of the vax?
No,
Not at all.
it's totally wrong. Remember, we're dealing with a wholly healthy person. There's nothing wrong with the person.
Exactly.
And his work is not affected in any way, so you can never go and claim that it's poor work performance or ill health or incapacity. It's impossible, and we've had quite a few of those coming to CCMA, and then the wheels fall off. The moment we really start testing the law and we're quoting Schedule 8 to the Labour Relations Act, that's the guidelines for dismissal, and we're quoting Section 192.2, the wheels fall off and the employer, the money starts rolling because they realize they will never win the case.
Okay. And then someone else wanted advice about the Department of Education.
What about the Department of Education?
Well, that's what I saw. Department of Education, they just want advice then.
Yeah, I'm not sure. At this point in time, there's not forced vaccination of state-paid Department of Education paid teachers. It was rather the private schools who adopted, and especially Karo. I'm always confused as to how to pronounce the name of the private schools. I've dealt now last week with a huge number of those teachers from private schools because they started adopting this silly notion of mandatory vaccination, which is actually illegal. Once again, thank you, Rapport, for clearing that up for us. Thank you so much. But yes. But teachers being paid by state, there's no forced vaccination as per all the other state employees. You can't be forced at this point in time.
All right, and well, that's it for now. And then we just want to know, what do you guys think about a monthly newsletter? And you can say what you want us to write about, or any ideas? What do you think about it?
Okay, I want to also just throw in the last thing. Once again, if you're faced with dismissal and you've not been dismissed yet, contact me please so that we can save that job for you. I've had tremendous success since yesterday, and I don't want to brag about it, but since that video went out yesterday, a lot of the employees who called me the day before, that was on... No, it was Monday, because this morning people started to phone me back to say to me that they've been called back to the workplace. So it works. If you simply quote law to employers and you say to them, Mr. Employer, you've been misadvised, you cannot do this to your employee. Here's the law. Then usually they botch for the very simple reason you can't fight the law. If the law in black and white, black letter law says the following, how can you fight it? And most often employers are just simply misadvised. I've seen that now often. So if you're not dismissed yet, try to reach me through all the chaos and all the other. Maybe you're the strong one that swims the hardest, and then you get to me first. But the long and the short is, please come in contact with me so that we can try to save your job. If you've been dismissed already, then go to ccma.org, go and download your 711, refer that case. If you've been sent home, my long video, 15-minute video of I think it was yesterday, please go and listen to that video. It sets down what you must do if you're suspended, but it also ends up where you refer a case of unfair suspension to CCMA. Use the mechanism of CCMA. I know some of the people feel that CCMA is failing them. I have my doubts about CCMA in certain areas and certain commissioners, etc. But on the whole, it remains one of the most effective weapons that we have. And it's cost effective. That's the big thing. And once again, I'm sitting now with a workplace where I think it was 52 employees or something. It was more than 50 were dismissed, and I referred those cases for them individually. Just think of the chaos inside that company now, because they have to go and fight 50 plus cases now at CCMA individually. It causes havoc, and that is why it still remains a very effective tool. And even if we settle most cases, if not all of them are settled, so even if we go to the worst case scenario and the person cannot be put back into the workplace, at least he's getting a certain amount of money out of the whole thing.
All right, and then just your contact information, where people can get a hold of you.
Well, you know it better than me.
The email address and your telephone number. The email address is ccmalitigation@gmail.com. And his contact number, but please, only WhatsApp. Not call, because there's just too many. It's 073 437 8187.
Okay.
All right,
And
that's
that,
it.
Mrs. van der Merwe,
I still have to get used to that.
yeah, let me also not say too much on that. Mrs. van der Merwe, that ends off this video, this live feed. Once again, guys, so thank you so much for everything that you are doing on this group, on Facebook, Telegram, my own personal profile. We're really now stacking up the numbers. If you go month on month, usually my engagements on my page is this Facebook page you're sitting on right now. Let's wiggle the nose again. But anyways, it runs up to 1.5 million plus per month over a stretch of 28 days. For some reason, Facebook counts on 28 days. I don't know why. It's something about the zombies maybe, but it runs to over 1.5 million. Now, people, if we can reach 1.5 million people, we can reach 15 million people. Why not? We simply need the numbers. So I really thank you guys. We went through 40,000 on Sunday. My Telegram will go through 20,000 tonight. It was on 19,900 and something earlier this evening. It will go over that mark. So we're racking up the numbers, but we can bring in a huge amount of our fellow South Africans onto this page. So please invite all your friends. Please bring them in. Gosh, that was sorry. Hitting the hammer even harder. But thank you so much for everything and all the support that we are getting. Without you, we can't do it. Then we're wasting our time.
There's just one last question that I saw now. Someone asked about Sanlam that doesn't want to accept religious or any underlying conditions. They just don't accept it.
Yeah, look, Sanlam must play the game out. They must play the game out. We will see where Sanlam goes from here. If they go any of the routes of either retrenchment, poor work performance, incapacity, whatever, we will counter them. We will go and fight them as we've been fighting now the last 2 months. And we will win. We will win them.
But obviously what they're doing is not right.
Yeah, it's illegal. It's illegal, and it's not going to become legal. I can also tell you that. And even if it becomes legal per se, they still have to go through all the little hurdles and jump through all the hoops of the Labour Relations Act and dismissal law. Yes, there is actually a term called dismissal law. Go and read your Grogan. Grogan being the most recognized author in South Africa relating to labour law. But if you go and look at dismissal law, it's very difficult in any event for an employer to dismiss, notwithstanding this whole issue of COVID.
Yeah. Okay, that's it for now.
Okay.
All right.
Right, I will see if I have time tomorrow for videos. I hope I will. It will also be quite late. But yeah, thank you so much, guys, and have a very nice evening and sleep well.
Okay.